Want to know how the federal criminal defense attorneys at the Rossen Law Firm saved a client of ours from upwards of 20 years in federal prison, as well as $57 million as part of a massive Ponzi scheme? We're going to discuss with you the steps to make that happen. Hi, I'm David Tarras, partner at the Rossen Law Firm. I'm here today to talk to you about what to do if you're contacted by the federal authorities. Now, the federal authorities can reach out to somebody in a few different ways. You might get a knock on your door. You might get a subpoena. Overall, the most important thing to consider is that if you're ever contacted by the federal authorities, you need to contact a federal criminal defense attorney. And that's us, and we're going to talk about why. Step one, when you're ever contacted by the federal authorities, is for us as your attorneys, so you can be protected and maintain your Fifth Amendment right to remain silent, for us as your attorney to contact law enforcement so you don't have to. And law enforcement is totally fine with that. They actually like in the federal system when attorneys are involved, because we can facilitate potentially whatever the nature of their investigation might be, in the best interest, of course, always in the best interest of our client. So step number one, we contact the federal law enforcement authorities for you and find out, why do you want to speak to our clients? A federal authority or a federal agent might be contacting you because you are a witness to a federal crime. They might be contacting you because you are a suspect in a federal crime, or they might be contacting you because you are the target of a federal investigation. Those are the three really important categories to consider here: witness, suspect, and target. And where you fall in those three categories is crucial to determining what the ultimate outcome of this contact with federal authorities is going to be. Let me give you an example of a case we had. A client of ours, Mary, was contacted by the Department of Defense. Now, she was contacted because there had been an ongoing civil case, now a civil case, not criminal, relating to allegations of a very, very large securities fraud. It was a Ponzi scheme situation, multi-tiered Ponzi scheme, resulting in over $57 million of loss. Now, where did Mary fall in this situation? Mary was in the middle of the scheme. When Mary contacted our office, she was not sure if she was a witness. She was not sure if she was charged with the crime. She was not sure if she was the target of investigation. That was for us as her attorneys to find out, and to find out quick. Because if we can get in quick, like we did with Mary, we have a lot of options. So in that situation, we contacted the agents right away. We asked, why are you looking to speak with Mary? Can we, as the attorneys, have a sit down with you prior to Mary having to come in and potentially speak to the agents or the federal authorities in that matter herself? So we spoke to the federal authorities without Mary present to find out, while she was safe, comfortable, and protected, what exactly it was that they were looking for. Was she a witness? Was she a suspect? Was she a target? It turns out that Mary did have a significant amount of criminal exposure for her role in this very large, over $57 million Ponzi scheme. What we were able to do, what was the ultimate goal, was because we became in early to the matter, we were able to make it clear through presentation of evidence on our end and on behalf of Mary that she was not a suspect in this matter. She should not be considered a suspect. She should not be considered a target. In fact, she was a witness, and a valuable witness, to an ongoing criminal investigation. We were able to get her off of all the lists of suspects, targets, and onto the right track. Now, things are going great for Mary. The criminal case is proceeding against the people who should be being prosecuted. Mary is no longer considered a suspect or a target in that investigation because we were able to come on early enough to explain to the Department of Defense why it would be best to have her as a witness in that matter. Now, a lot of our clients here in the federal cases that we do are not witnesses. They are suspects, they are targets. If so, there are still a lot of things that can be done to protect that individual, to protect our clients prior to the case being started. Step two, if there is already a prosecutor, in this situation, the prosecutor would be an assistant United States attorney. If there's a prosecutor on board, we want to set up a meeting as soon as possible. Sometimes our client is present at that meeting, sometimes it's just the attorneys. And what happens at that meeting is something that us federal criminal defense attorneys often refer to as a reverse proffer. The important thing about this meeting is that the federal authorities, along with the prosecutor, the assistant United States attorney, are going to essentially lay their cards out on the table. They're going to say, here is what we have, here is what we have discovered so far during our investigation, and here is where we feel that your client falls within that spectrum, within that investigation. That is crucial, because then we know how to protect our client, we know what their potential exposure is, and how to then proceed to something that's called a proffer. That's when we will meet with our client and discuss the pros and cons of going and having an initial meeting with our client present with law enforcement and with the prosecutor, if a prosecutor is already on board and making decisions in the matter. So that second meeting is crucial to decide, can our client, with our advice, facilitate or benefit the investigation or the prosecution that the federal authorities have ongoing in any form? Or is it the best thing for us to just simply exercise our client's Fifth Amendment right to stay silent, to continue tracking the investigation, make sure our client is fully protected, and that no matter what comes, that we do everything in our power to reduce, to protect, to get them even a small victory of lowering the potential criminal exposure from the start. We were able to save her from a substantial, significant amount of criminal exposure. A $57 million Ponzi scheme, a conspiracy with co-defendants in a very, very serious situation, could have been looking at 20 years or upwards of prison, as well as potentially $57 million in restitution if she was to be charged as a conspirator. We came in early. We took the steps that were necessary to contact law enforcement on behalf of our client so she didn't have to make sure that from the get-go, from day one, we are changing the narrative. She's not a suspect. We made that clear with evidence, with argument that we presented to the federal government. Now, at most, she is a witness, and we have saved her a significant amount of potential criminal exposure. These are all the keys: getting in early, meeting with the prosecutor early, meeting with the federal agents early, understanding how the process works as a federal investigation and a federal prosecution builds, which we understand intimately, and get involved early in for our clients to make sure that the narrative is changed, that no matter what is to come, our client is protected, and that we ensure they have the least criminal exposure possible, if any.